10 seconds, 5 seconds. Start. Provisions for household industries in residential areas does not mean converting residential houses in the commercial shops. It only means permitting activities of household industry in a part of a residential property. Be that as it may for the present, as we are considering the cases of small shops meant for day-to-day basic needs, but are considering large-scale conversion of residential premises for commercial use. If in the master plan the land use is residential, MCD cannot sanction the plan for any purpose other than residential. We have seen the affidavits. We are sorry to note that the affidavits do not specifically deal with the points in issue. Only general averments have been made. They show that the parties concerned have not even touched the tip of the iceberg. Unauthorized encroachment and illegal construction, even as per the affidavits, are increasing at an alarming rate. The MCD is now directed file another affidavit informing this court as to why no requisite action has been taken for stopping the gross misuse of the residential buildings for commercial purposes and in the construction of commercial buildings in residential areas where only residential houses are permitted. This court cannot remain a mute spectator. There was to be a will to do it. The things cannot be permitted to go on in this manner forever. On one hand, various laws are enacted, master plans are prepared by expert planners, provision is made in the plans also to tackle the problem of existing unauthorized constructions and misusers, and on the other hand, such illegal activities go on unabated openly under the gaze of everyone without having any respect and regard for law and other citizens. In the case of DDA versus Rajendra Mittal, a division bench of this court observed that the use of residential premises for widespread commercial activities is prohibited. Earlier, another bench of this court had echoed similar words. As regards municipal laws providing for power of demolition, it was observed that while interpreting municipal legislation framed in public interest, a strict constitutional approach must be adopted. In 1996, in the case of Anil Kumar Khurana versus MCD in respect of blatant unauthorized constructions, it was observed that It cannot be said that the Commissioner MCD has a discretion to order demolition or not, and vesting of discretion in the circumstances would itself be arbitrary and illegal. In conclusion, it was stated that despite warning and caution given by the apex court that stern action will be taken against unauthorized constructions and misuse, these activities have gone on unabated without any effect on the unscrupulous builders and purchasers of these spaces. It is therefore necessary to send a message loudly, clearly, and firmly to all such people that courts will not come to their aid. If, in spite of this warning, anyone indulges in such unauthorized construction in any manner, he would be doing it at his own risk and peril, and would not be heard to say that he has made large investments.